Citizenship. Article 5. Citizenship at the commencement of the Constitution. At the commencement of this Constitution, every person who has his domicile in the territory of India and Clause A, who was born in the territory of India, or Clause B, either of whose parents was born in the territory of India, or Clause C, who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement, shall be a citizen of India. Article 6. Rights of citizenship of certain persons who have migrated to India from Pakistan. Notwithstanding anything in Article 5, a person who has migrated to the territory of India from the territory now including in Pakistan shall be deemed to be a citizen of India at the commencement of this Constitution if Clause A, he or either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935 as originally enacted, and Clause B, subclause 1, in the case of where such person has so migrated before the 19th day of July 1948, he has been ordinarily resident in the territory of India since the date of his migration, or subclause 2, in the case where such person has so migrated on or after the 19th day of July 1948, he has been registered as a citizen of India by an officer appointed in that behalf by the government of the Dominion of India on the application made by him therefore to such officer before the commencement of this constitution in the form and manner prescribed by that government, provided that no person shall be so registered unless he has been resident in the territory of India for at least 6 months immediately preceding the date of his application. Article 7. Article 7. Rights of citizenship of certain migrants to Pakistan. Notwithstanding anything in Articles 5 and 6, a person who has after the first day of March 1947 migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be a citizen of India, provided that nothing in this article shall apply to a person who, after having so migrated to the territory now including in Pakistan, has returned to the territory of India under a permit for resettlement or permanent return issued by or under the authority of any law, and every such person shall, for the purposes of Clause B of Article 6, be deemed to have migrated to the territory of India after the 19th day of July 1948. Article 8. Rights of citizenship of certain persons of Indian origin residing outside India. Notwithstanding anything in Article 5, any person who or either of whose parents or any of whose grandparents was born in India as defined in the Government of India Act 1935 as originally enacted, and who is ordinarily residing in any country outside India as so defined shall be deemed to be a citizen of India if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country where he is for the time being residing on an application made by him therefore to such diplomatic or consular representative, whether before or after the commencement of this constitution, in the form and manner prescribed by the government of the Dominion of India or the Government of India. Article 9. Persons voluntarily acquiring citizenship of a foreign state not to be a citizens. No person shall be a citizen of India by virtue of Article 5 or be deemed to be a citizen of India by virtue of Article 6 or Article 8 if he has voluntarily acquired the citizenship of any foreign state. Article 10. Continuance of the rights of citizenship. Every person who is or is deemed to be a citizen of India under any of the foregoing provisions of this part shall, subject to the provisions of any law that may be made by the Parliament, continue to be such citizens. Article 11. Parliament to regulate the right of citizenship by law. Nothing in the foregoing provisions of this part shall derogate from the power of Parliament to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Part 3. Fundamental Rights. General. Article 12. Definition. In this part, unless the context otherwise requires, the state includes the government and parliament of India and the government and the legislature of each of the states and all local or other authorities within the territory of India or under the control of the government of India. Article 13. Laws inconsistent with or in derogation of the fundamental rights. Clause 1. All laws in force in the territory of India immediately before the commencement of this constitution, in so far as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. Clause 2. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. Clause 3. In this article, unless the context otherwise requires. Subclause A. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. Subclause B. Laws in force includes laws passed or made by a legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. Clause 4. Nothing in this article shall apply to any amendment of this constitution made under Article 368. Right to equality. Article 14. Equality before law. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Article 15. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Clause 1. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Clause 2. No citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to subclause A. Access to shops, public restaurants, hotels, and places of public entertainment, or subclause B. The use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. Clause 3. Nothing in this article shall prevent the state from making any special provision for women and children. Clause 4. Nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and the scheduled tribes. Clause 5. Nothing in this article or in subclause G of Clause 1 of Article 19 shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste or the scheduled tribes, in so far as such special provisions relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30. Clause 6. Nothing in this article or subclause G of Clause 1 of Article 19 or Clause 2 of Article 29 shall prevent the state from making, subclause A, any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in clauses 4 and 5, and subclause B, any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in clauses 4 and 5, in so far as such special provisions relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30, which in the case of reservation would be in addition to the existing reservations and subject to a maximum of 10% of the total seat in each category. Explanation. For the purposes of this article and Article 16, economically weaker sections shall be such as may be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Article 16. Equality of opportunity in matters of public employment. Clause 1. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Clause 2. No citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for or discriminated against in respect of any employment or office under the state. Clause 3. Nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government of or any local or other authority within a state or union territory any requirement as to residence within that state or union territory prior to such employment or appointment. Clause 4. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens which, in the opinion of the state, is not adequately represented in the services under the state. Clause 4a. Nothing in this article shall prevent the state from making any provision for reservation in matters of promotion with consequential seniority to any class or classes of posts in the services under the state in favor of the scheduled caste and the scheduled tribes, which, in the opinion of the state, are not adequately represented in the services under the state. Clause 4b. Nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance with any provision for reservation made under Clause 4 or Clause 4a as a separate class of vacancies to be filled up to be filled up in any succeeding year or years, and such class of vacancies shall not be considered together with the vacancies of the year in which they are being filled up for determining the ceiling of 50%. Reservation on total number of vacancies of that year. Clause 5. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. Clause 6. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in the favor of any economical weaker sections of citizens other than the classes mentioned in clause 4, in addition to the existing reservation and subject to a maximum of 10% of the posts in each category.